Jones v. Mayer. Seminal case, Discrimination in Real Estate Restricted. The Civil Rights Act of 1866 established that discrimination within real estate is illegal. It took a long time before the law was tested, and it came in the form of the culture-changing Supreme Court case of Jones v. Mayer in the year of 1968. In the case, a person tried to purchase a home in a certain neighborhood but was not allowed because of his race/color. Those arguing this was okay said that the Civil Rights Act of 1866 only applied to the government's interaction with citizens and not to private citizens' interaction with each other. On appeal, the court found that the law applied to private citizens interacting with each other too. The series of steps taken by the laws has now resulted in our current use of the Equal Opportunity Housing Provider logo and Code of Conduct for Real Estate Professionals. Close of escrow. When terms and conditions of the instructions are fulfilled. Escrow is the process of having an unbiased third-party administrator the details of a real estate transaction. Escrow is the process of having an unbiased third-party administer the details of a real estate transaction. The escrow agent uses the escrow instructions as the conditions and rules of the transaction. The escrow instructions are agreed to by the seller and the buyer and delivered to the escrow agent at the opening of escrow. Escrow instructions can be amended during escrow by the mutual written agreement of buyer and seller. When the escrow instructions, its terms and conditions are fulfilled, escrow closes, quote, close escrow, end quote, has become a part of our common language, as it represents the completion of a deal and the time when all get what they want. Seller gets property sold, buyer gets the property, and the agent gets paid. Estate in fee. Freehold estate, perpetual estate, estate of inheritance. An estate is the ownership interest or claim that a person has in real property. There are two types of overall estates: freehold estates and less-than-freehold estates. Freehold estates are owned and less-than-freehold estates are rented or leased. There are two types of freehold estates: estate in fee and a life estate. A life estate is based on the life of a specific person. Estates in fee are not based on the life of a person. There are two types of estate in fee: the fee simple absolute, which is the completely unrestricted in any way estate, and fee simple qualified. Fee simple qualified is based on some condition, precedent, or subsequent, like the property given to the city had to be used as a library, or the donating family wanted the property back. Since an estate in fee is not based on the life of a person, it is a perpetual estate or an estate of inheritance. When a home is purchased under normal conditions in America, the estate is listed on the title as a fee simple absolute, which is a form of estate in fee, which is a form of freehold estate. An estate in fee is a perpetual estate or an estate of inheritance. Synonyms: fee simple estate, perpetual estate, estate of inheritance. Related words: estate. Less-than-freehold estate. Estate type, held by a renter. The word estate means an ownership interest or claim a person has in real property. There are two main types of estates: freehold estates, which are owned, and less-than-freehold estates, which are leased or rented. A less-than-freehold estate is also called a leasehold estate. Freehold estates, those owned, fall into two types: life estates, those that last for the life of a designated person, and estates in fee, which separates into two types, one which is qualified, a fee simple qualified / defeasible, which has some condition tied to it, like you must use it as a library, and the second is called fee simple absolute. Most people who buy a home are getting a fee simple absolute estate, one which is owned and unrestricted in any way. Renters only have a temporary claim or use in a property according to the terms of the lease, so their estate type is a less-than-freehold estate, or a leasehold estate. Antonyms: freehold estate. Related words: estate. Lead-based paint hazards disclosure. Pre-1978 homes must have lead in the interior paint. Pre-1978 homes might have lead in the interior paint. All properties with structures built before 1978 must have a disclosure included in sales transactions and lease transactions regarding the possible presence of lead in the paint. Lead was a very successful ingredient to paint for 100 years. One of its characteristics is that when it is old, lead-based paint peels and flakes. Lo and behold, babies and little kids can't resist scraping and eating these paint chips and flakes. Once lead gets into the body, it doesn't come out naturally. Lead poisoning affects the brain and motor skills. Parentheses, just like the Romans who used lead in their drinking water piping systems and were poisoning their entire population. End parentheses. The Residential Lead-Based Paint Hazard Reduction Act of 1992 made lead in residential paints illegal and required the disclosure that a home built prior to 1978 may have lead in the paint on the walls. The disclosure also explains lead poisoning and its symptoms. Expiration of offer. Limited time within which an offer may be accepted. When making an offer on real estate, it is necessary to place a time limit on the offer. Reasons for a time limit include the offeror wanting to move on if the seller does not accept, and a time inducement to encourage the seller to not let an offer linger. Expiration of offer is a limited time within which an offer may be accepted. Commingling. Mixing client money with personal money. Commingling is the act of mixing client money with personal money, and it is illegal. Commingling is a bad idea for many reasons, one of them being that it leads to conversion. Conversion is when a broker spends client money for her own purposes. Commingling is mixing, parentheses, illegal, end parentheses. Conversion is stealing. Brokers get fingerprinted and FBI checked when they get their license from the state for a reason. The reason is that brokers handle large amounts of other people's money in a fiduciary, parentheses, relationship of trust and confidence, end parentheses, manner. Brokers keep client funds and personal funds separate to help ensure integrity. Related words: conversion. California Civil Code. Real estate-related agreements must be in writing. The California Civil Code requires that several types of contracts be in writing to be valid and enforceable by law. The types of contracts include contracts with terms beyond 1 year, cosigner agreements, agreements based on marriage relationship, real estate agreements, including leases longer than a year, real estate sales agreements, and real estate agency agreements for brokers and their associate agent brokers, agreements outside of one's lifetime, and any hypothecated loan agreements. The California Civil Code is based on the Statute of Frauds, which found its way to America from English common law adopted in 1677. California Civil Code and the Statute of Frauds have the purpose of keeping trust in transaction. Trust in transaction is the idea that without trust, commerce and even all society breaks down. Department of Housing and Urban Development, HUD, HUD. Government agency to promote quality housing, HUD, the U.S. Department of Housing and Urban Development, was chartered in 1934 with the responsibility of developing policy and programs to improve housing in America, and enforcing fair housing laws. Some of HUD's programs include providing rental assistance for low-income families, financial assistance to revitalize deteriorated neighborhoods, attention to low-cost housing through multifamily mortgage insurance, revitalization of abandoned properties, and mortgage insurance for individuals to buy homes with a low down payment. One of HUD's programs is the Federal Housing Administration FHA program. Complaints regarding the Fair Housing Act are to be filed with HUD. The Fair Housing Act gave HUD the authority to hold hearings and to issue subpoenas. HUD's administrative law judge can order relief, assign damages, make injunctions, or other reliefs for Fair Housing Act violations. Related words: Fair Housing Act, administrative law judge. California Financial Discrimination Act, the Holden Act. The right to credit based on consistent standards. The California Financial Discrimination Act of 1977, or the Holden Act, came about from the now illegal practice of redlining. Banks would literally lay out a map of the city and draw red lines around areas they would decide not lend in. When an application for a loan was for a property within the red-lined areas on the map, the applications were declined. The result was groups of people and areas of town neglected from development. The Holden Act works to make sure that lending is based on credit worthiness and not illegal and unfair bases of deciding credit worthiness. The Holden Act is the right to credit based on consistent and non-discriminatory standards.